Hello and welcome back to part 5 of misrepresentation. Okay, last time we're talking about restitution and rescission. Now under this section I want to talk about restitution without rescission. Okay, so what is it basically? What is this? Basically, restitution is basically a compensation paid to a party for loss or injury. Rescission is just turning the clock back before the contract was made. It will undo the contract and unwind the transaction. Alright? There is a time when undoing the contract is not possible, but restitution is the alternative. The traditional doctrine of equity will give no relief in restitution. If restitution, okay, so sorry. The traditional doctrine of equity will give no relief if restitution could not be granted. In a British Columbia Court of Appeal case, Bank of Montreal versus Murphy, the court are not restricted to the remedy of rescission where a contract is induced by misrepresentation and awarding rescission does not do justice. In such case, a compensation would be paid, preferred over rescission, or a combination of compensation and rescission may be given. Now, I'd like to bring your attention to the British Columbia Court of Appeal decision in Guild versus Bulcht. That's Guild versus Bulcht, as in B-U-C-H-O-L-T-Z. I'm not sure if I pronounced it right, but okay. In this case, the Court of Appeal held that Mr. Gill should be the legal owner of his property. The Chamber Judge also decided that Mr. and Mrs. Bolt and 4337 were entitled to maintain their mortgage as valid charges. The judge relied upon Section 23 of the Land Title Act. However, the Court of Appeal reversed the Chamber's judge decision. Both mortgage would be invalid because it was proven that the registered owner and mortgager had participated in a fraud. Alright, so next part of misrepresentation. Section F. Liability and tort. In a contract, if a contract was induced by misrepresentation, the misrepresentee may be able to seek claim for damages in tort. This claim would be under the tort of deceit. Any careless statement that contributed to a misrepresentation will permit a misrepresentee to make a claim in the court of negligence. The court of deceit is explained in the Perry versus Peake case. Number 1, okay, you need a proof of fraud. Number 2, fraud is proven when false misrepresentation is made, A, knowingly, and B, without belief in its truth, and C, reckless or careless whether it is true or false. So, Derry versus Peake is a case on the tort of deceit. The company's prospectus stated that it had permission to use steam trams, but it did not have the right to use steam trams. The use of steam power was subject to the Board of Trade's consent. The company issued the prospectus with the assumption that they will get the permission. When the business became bankrupt, shareholder in the company sued the company on the faith that the misstatement. Since the statement was made with the assumption and the belief that it is true, the statement is not an act of deceit. The House of Lords allowed the appeal. The defendant cannot be liable because they honestly believe in the statement to be true. Alright. McKenna states that in recent years there have been more recognition of liability and negligence for carelessly made pre-contractual misstatement. Page 349. Liabilities and economic loss due to negligence misstatement are also pretty recent. Alright, so let's look at this case. It was in Headley, Bryan versus and Company versus Heller and Partner, where it was first recognized that negligence of misstatement allowed liability for economic loss. So, Hedley Burns was induced into entering into an agreement with Easy Power Limited, based on the Heller's report. Easy Power went under, and Hedley lost a large sum of money on the contract. Hedley sued Heller for negligence because the information was negligent misrepresentation. Heller's argument was that there was no duty of care. Okay. However, the Court of Appeal states that the relationship between both parties was sufficient to create a duty of care. Heller should have known that the information provided could have been relied upon for entering into the contract and suffered economic loss. In this case, Lord Reed states, where there is a contract, there is no difficulty as regards the contracting parties. The question is whether there is a warranty. Okay, in the Hedley case, liability will extend into pre-contractual sphere. A negligence false statement of A given to B could expose A to tort liability in a suit brought up by B if B relied on the negligent false statement entered into the agreement with C. Okay, so there was a special relationship between A, B, and C. Alright, in Esso Petroleum Company versus Mardon, Esso entered into a lease agreement with Mardon. Esso gave an estimate of petroleum consumption in that area, which induced Mardon into entering into the agreement. However, the volume of sales was not exactly as Esso has stated, and Mardon made a substantial loss. Okay, Mardon was successful in a counterclaim for damages for negligent misrepresentation and collateral contract. Lord Denning states, if a man who has or professes to have special knowledge or skill makes representation by virtue thereof to another with the intention of inducing him into entering into a contract with him, he is under a duty to use reasonable care to see that the representation is correct, and that the advice, information, or opinion are reliable. If he negligently gives unsound advice or misleading information or expresses an enormous opinion, thereby induces the other side into a contract with him, he is liable for damages. Page 350. Okay. In the Court of Appeal, Sod Corporation Inc. versus Thesis, the plaintiff bought stocks of a bankrupt furniture store based on the statement that the defendant made by the defendant trustee. The statement was about how to calculate the retail value of the goods in question. The method of calculation was incorrect, and it was an overstatement of about twice the fair market value. The advice of the defendant was held to be negligent misstatement. The defendant would be liable for damages for the loss, for the plaintiff's loss. And so the case, Sod versus Thesis case, would be the standard doctrine applied in a number of decisions in Canadian courts. So a common theme in all these cases is that there must be a special relationship between all parties. The defendant must be engaged in the business in which they are providing advice. There would be a special relationship if the misrepresentee relied on the misrepresenter's statement, if the reliance was foreseeable by both misrepresentee and the misrepresenter. There would be no special relationship if the advisor was not an expertise or having special skill or knowledge. So, alright, that's it for now. Next I want to continue on later on into the subject here, okay? So until next time, please come back and listen to more on misrepresentation. Thank you for listening. Have a good day.